Good morning. Are you Manuel Cardenas
Yes.
Jr.? And Mr. Cardenas was previously in court, entered a plea of guilty in cause number 26 DCCR 0040 to the third-degree felony offense of injury to a child, elderly, or disabled individual. And that was for an agreement of 5 years deferred probation. I received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
Not from the defense.
Judge, my only position would be that obviously as indicated by the PSI, this incident does not stem from his criminal history, so to speak, but more likely probably a mental health or a narcotics induced incident. It's obviously concerning with regard to his father. We'd ask that a no contact order remain in place, but defer to what you think is appropriate.
Okay, so Mr. Cardenas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes, among other things, but that does include that you will enter and successfully complete the safety program. So that can help you with any drug or alcohol related issues. When you get out, you will also be placed on the mental health initiative caseload to help with any other issues that you may be having, so that you will have all the tools to be able to be sober, healthy, and obviously not have anything like this happen again.
Yes, ma'am.
You will also be required at this time to have no contact or communication with Manuel Cardenas Sr., your father. That's until further order of the court. And so if there becomes a time on probation where you feel like you're in a good place and he wants you to be around or something like that, you have to go through probation. You have to get my permission to do that. He can't give you permission.
Okay.
So he can't say it's fine, come over, it's Christmas. If you do that without my permission, it's a violation of your probation. Okay. If you do everything you're supposed to on this probation, you're about to get all the tools you need to be successful. You don't have a felony conviction. You should be able to finish it. And at the end of your probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction on your record.
Sounds good.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and I could send you to prison for anywhere in the punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Okay.
Mr. Vasquez, you have Corey Como.
Me.
Oh, I just saw him. Did he go somewhere? Well, don't call. I don't know where Joel is, so I'll skip that. Let's see. Mr. Rojas, you got Jimmy Couch.
Couch.
You're here for Bruce?
Yes, ma'am.
Okay, I'll take care of that just a second.
Okay.
Yeah, I know that. There you go. How you felt? You know, you do not see
This is computer stuff.
Good morning, Judge.
Good morning. Are you Jimmy Couch?
Yes, ma'am.
Y'all give me just a second. I just don't know.
Okay. We're gonna like a statue. I'm thinking now that it's saying attempted.
Yes, well.
That's coming. Mr. Couch,
Yes, ma'am.
pay attention this way. All right. Will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Couch, in clause number 26, DCCR 0328, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted burglary of a habitation. And that's from January 29th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine. You'd be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Oh, yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Ms. Malfino?
Judge, the state would respectfully object to any type of PSI bond in this case because of the fact that we're going to very strongly urge the court to consider safety. I have met multiple times with the complainant, Ms. Couch, in this case. She is actually present in court today. I think there is an underlying severe substance abuse issue that has contributed to all of these issues. And that will be the position of the state
Okay.
to ask for safety. And I'm afraid that if he's out in the interim, it will derail that and also this absence of contact with her at this point.
So,
I
Go ahead.
understand that's the state's
Sure.
position. Judge. Mr. Couch is requesting that you do consider allowing him to be released. He's been in jail now for
4 months
4 months. He's getting some taking AA classes in jail.
from Rocco.
He's got some health issues that he desperately wants to get on the outside and
Yes, ma'am.
get addressed.
I have a spot on the lung. I was supposed to be in Badlands Hospital for another PET scan and another biopsy. And it's just getting worse by the day.
well, here's, if Mr. Rojas, if you want to get some information to the court between now and sentencing, I can bump something up with regard to a bond hearing. But today, based on the allegations and the concern, what I'm going to do is not change the bond. I am going to ask probation to do a go ahead and get a substance abuse done assessment during that, so that we have everything in place when we come back for sentencing. All right, you
Thank
can go back with the bailiff.
Okay, thank you.
So on Bragan Hulsman, that's the one you talked to me about, right?
Yes,
Mr. Did y'all,
we did.
oh, okay, sorry.
Actually, gonna be a misdemeanor since he can do it.
Good morning. Are you Bragan Hulsman? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hulsman, in cause number 26 DCCR 0199, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. And that's from January 7th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, sure.
Do you fully understand them?
Sure.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for, hold on, it's back. A 2-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Part of that would be that you would follow any recommendations with regard to any mental health care issues. Do you understand? State tenders number one.
No objection.
It's admitted. And are you a US citizen? All right. Is there any evidence that Ms. Schulzman is not competent?
None that has not already been addressed, Judge.
Okay. All right, then, Ms. Schulzman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine, and you're ordered to follow all of the rules and conditions of probation, including any mental health care. If you do all of that, this is a great opportunity because you won't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is dismissed. The other side of that is if you violate any condition of probation, you can be brought back in the court and you could be convicted and sent to our Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get some instructions from probation today so that you'll know exactly what to do when you're released from jail. Make sure you do all that, okay? All right, you can go back. John McMillan. Mr. Rojas and Ms. Muffin.
Hold on that for 1 second.
Sure.
Well, call, I sent a letter. I don't need to go grab a sleeve from that.
Okay, I'll hold it. Ms. Shipley, you're here on Brandon Lewing for Mr. Smith.
Yes, Your Honor. Brandon.
Morning.
Good morning. But I feel
And they take you down the right now. It's still gonna be harder than.
Yeah, you do.
Good morning, sir. You're Brandon Lewing. And Mr. Lewing is charged in cause number 25 DCCR 1402 with the state jail felony offense of unauthorized use of a vehicle. Ms. Shipley's here for Mr. Smith, and is there an announcement?
Judge, yes, Your Honor. Mr. Smith had to be in another court, and so Mr. Lewing and Mr. Smith have been working on some things, and they were able to provide Ms. Malfino with some additional information. And we're asking for a little bit of time for Mr. Smith and Ms. Malfino to consult on those matters.
And Judge, I have spoken with Ms. Shipley this morning. That is correct. Mr. Smith sent me an email from the defendant yesterday, and since he's here, if I may, I would just like the defendant to know I have taken it into consideration. I have rewatched the video, although there is a portion of his email that I agree with respect to the ski mask. I just want him to know where I'm coming from.
Sure.
His stack of felonies that is this high doesn't lead me to take everything he says in that email that is self-serving to heart, but I will, based on that, be willing to discuss with Mr. Smith reconsideration of the offer if the court would allow us that time. But I just wanted Mr. Lewing to know I did look at that and what my position is.
Okay, so we'll just do a normal reset. That'll give your attorney and time to visit with Ms. Malfino, and when we come back, we'll get an announcement at that next court date.
Thank you.
Thank you, Judge. And then
All right.
Mr. Smith will be out to see you as soon as he meets with Ms. Malfino. Thank you.
Michael Martin, also, Ms. Shipley.
Yes. This is a request for a
Michael
mental health
Moore.
evaluation.
Has something been filed?
No,
Okay,
but that's where he's going.
so this is, we don't need Mr. Martin. I'm gonna reset it. If you'll get Mr. Smith, if he needs, so because he's hired, if you'll make sure if he needs, is requesting a court-appointed evaluation for competency, make sure he also attaches the affidavit of indigency. That gets missed sometimes, and because you're hired, I have to have an affidavit of indigency and to make that determination before someone's appointed. Otherwise, you guys would have to get that taken care of with his.
Absolutely.
Okay, makes sense?
Yes.
All right. And so he's reset Michael Martin.
Yes, ma'am.
Mr. Vasquez? Lost him again. Let's see, Mr. Lewis, Ms. Holmes, you've got Brianne Williams, sentencing.
Brianne Williams?
Good morning. Good morning, you're Brianne Williams?
Yes, ma'am.
And this is cause numbers 26 DCCR, excuse me, 0531. Ms. Williams entered a plea of guilty in that case to a new offense of possession of a controlled substance, a third-degree felony. And then we've got cause number 1830512. Ms. Williams is on probation for injury to a child, and that's a third-degree felony offense. Entered pleas of true. Let's see, I see where. While I look at that, but there was an agreement, it appears, for a 3-year deferred probation, $500 fine, and ISF substance abuse track on the new case with continuing probation and ordering substance abuse, ISF substance abuse on that one. I've received the pre-sentence report and gone over it. Have y'all both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Let me go back and look at something. All right, so it was a 10-year deferred probation from May 20th, 2019 for that injury to a child or elderly, excuse me, individual. And it looks like she pled true to counts 1 through 5, which include that new offense of failure to identify, a new offense of public intoxication, being an out past curfew, and court assessed fees. So I guess what I have a question mark here and an issue and a question, which is why is it just 3 years on a third degree felony possession when we've already got a 10-year deferred on the other one? I just don't know that that makes sense to me for it to be that low of a number of years for a new offense while you're on a felony offense. I'm not opposed to the ISF and do it and going forward with probation, but I just don't think it makes sense to do a.
It could have been the length of time,
That she had already been.
right, because the new case, the new offense was from 2024, did not get indicted until this year. So I think that played a part
Okay,
in it.
but it was, okay, but it still was after she was on probation,
Yes,
but it
it
didn't
is.
get indicted for
And
a
I
long time.
believe when it originally occurred, that was addressed at a previous MTRP hearing. But it did not get indicted till 2 years later.
Okay, all right. Anything else then?
No, Your Honor.
No.
All right, Ms. Williams, with that explanation, I'm going to follow the agreements that you made with the district attorney's office. And cause number 26 DCCR 0531, find sufficient evidence to find you guilty. However, I'm going to follow that agreement and in that case, defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the substance abuse track of the of ISF. And then in cause number 18-30512, I'm going to find that you enter those pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. find sufficient evidence to find you guilty and revoke your probation in that case, but I'm not going to do that. I'm going to follow the agreement, continue you on probation, order as a condition of that probation that you enter and successfully complete the ISF substance abuse track as well. You're being given now all the opportunities that you're probably going to be given. So you're going to go to ISF, you'll get the tools you need in order to remain sober. When you get out, you'll have aftercare. You still have no felony convictions. You still got some great opportunities here to kind of get your life back on track, get off drugs and just live a normal life. If you don't do that and you don't take advantage of this and you continue to test positive and do the things that you did on this one, you're going to end up back in here and you could go to prison in each of these cases for up to 10 years. Do you understand? All right, I'm handing you the trial court certifications in each of those cases that shows that these were.
And that brings us to the end of another intense day in court. From a massive $300,000 bond in each case, to a defendant rejecting a 30-year plea offer and choosing to take his murder case toward trial, the stakes couldn't have been higher. The judge had to weigh public safety, probation violations, new allegations, and the defendant's constitutional right to have their cases heard in court. But what do you think? Was the $300,000 bond justified? And was rejecting that 30-year plea deal the right decision? Let us know your thoughts in the comments. If you found this courtroom breakdown interesting, like the video, subscribe, and turn on notifications for more real courtroom moments and legal analysis. Until next time, stay informed, and remember, every case has two sides, but the courtroom decides the outcome.